Lawyer Solictors, what is the strangest or oddest law that's won a case for you? The weirdest case I have ever dealt with was Jolie v. Palita, 1999, OJ, number 1728, SCJ. I did some research for this case when I was a law student. Some background. This was at a time when the Ontario Court of Appeal had held that, if there were any factual matters in dispute, a case could not be dismissed on summary judgment. That is not the case today. It was discovered that this position basically ruined summary judgment as a useful process, but it was at the time. In such a motion, all facts alleged by the plaintiff would be assumed to be true. What happened was this: a man sued, among others, the College of Dental Surgeons for persecuting him and interfering in his ability to live as a generic Martian. The plaintiff claimed he had been cloned from space debris NASA found in the 1960s. He claimed he had a genetic test to prove this, but it had been falsified by the CIA as part of the conspiracy against him. Well, naturally, this claim raises the concern that the plaintiff was bonkers, but there was no evidence, aside from his bizarre claims of that. In court, the case was decided on two alternate grounds. First, on the boring grounds that the case was patently frivolous and vexatious because it was absurd. However, it was also decided on the more entertaining basis of standing. Justice Epstein held that only a person could commence an action in Ontario. The rules of civil procedure define a person to be either a human being or a corporation. The plaintiff's whole case was based on him being a Martian. If he was not a Martian, his case had no merit. If he was a Martian, he lacked standing to commence a lawsuit in Ontario. In short, we now have precedent that Martians cannot sue in Ontario. That's hilarious. I love when actual legal precedent sounds like a hypothetical from a grade school mock trial. I had a case where a guy was charged for running a red light. The thing is, he had been sitting at the lights for 5 minutes and it hadn't changed. The wording of the specific section under which he was charged related to stop signs and traffic lights and referred to them as traffic regulation devices. I successfully argued that as the traffic light wasn't changing, it wasn't regulating traffic, and he got off. I couldn't believe it when the judge ruled in my favor. Neither could a police prosecutor. I got a pro bono client's removal by us cancelled. He had a low-level drug possession conviction from the early 1980s. During that brief period, the active ingredient of Imodium was illegal under state law but not federal law. So I successfully argued that they couldn't prove it wasn't a conviction for possession of a substance that was federally legal at the time, and as such was not subject to removal. The argument worked and my guy went back to his business and his family. 47 U.S.C. 227 B. Restrictions on use of automated telephone equipment. Law student working at law firm. We have a fax machine that gets tons of spam faxes. Our chief partner has a vendetta against spam, and he uses it to give us practice in researching and writing petitions. So we catalog each fax, send replies to take us off the list, document everything and wait for them to fax us again. Then we follow up with a FCC complaint and demand letter. A couple times this has ended up with the person getting mad and sending us retaliatory faxes, black sheets of paper. If they stop sending, we don't do anything. But we've gone to small claims a couple times and gotten $500 per page a couple times. We also got someone trying to sell drugs through fax, but we just turned that over to the police. Imagine sending a spam fax about drugs to a law firm. The Canadian Interest Act specifies that all interest must be specified in a per annum percentage. If it is not, it's struck down to 5% simple interest per year. The number of lenders and creditors who try to pull off a 4% monthly compound interest, but aren't familiar with that provision of federal law. I, for one, would like to hear a great bit more detail about this. I won a case where the defendant, New York City, tried to exploit a really stupid law, which I was able to use to win the case. This was a slip and fall case where my client had tripped on a piece of broken sidewalk outside of the Natural History Museum and shattered her arm and wrist. The law is that a property owner is responsible for the sidewalk directly outside of their property. The theory being, even if they can't fix it, they have a duty to warn people about hazards and mark the area off. The museum was owned by the city. There's another concept called sovereign immunity, which is that governments can't be sued without their consent. So the city had passed a very stupid law that they would be exempted from the rule that they can't be sued for sidewalk injuries unless you can show they were on notice of hazard. Meaning, you would have to show that you informed the Secretary of State, Governor, Mayor, etc. of the exact specific crack in the sidewalk before the injury occurs, and you had to do so in writing with ample time for the city to remedy it. 180 days in advance if I recall correctly. Under normal circumstances, this is impossible because no one anticipates tripping on the sidewalk 180 days in advance with the foresight to write a letter to the mayor about that specific crack. Luckily, someone did have that foresight, and there was a non-profit called Big Apple Maps which would go around the city and with maps of government property and record with insane specificity each and every crack in the sidewalk, pothole, protrusion, and other hazard, and then publish these maps while serving copies on the government, with the express I got a hold of one of these maps and visited the site. And I was able to take pictures of the section of the sidewalk where my client fell, and you could see newly placed concrete over the area in the exact position indicated on the map, showing where the sidewalk had been repaired after my client slipped. Basically, the government's attorney brought up the sovereign immunity defense and outlined all of the stupid steps I would have needed to go through to overcome their motion to dismiss. My response was, "Oh, you mean this?" and gave them the map. Immediate settlement. Had a friend trip over a huge crack in a sidewalk. The city tried saying they didn't know. I had submitted pictures and a complaint about the crack almost a year prior. He was very thankful I did so as it basically won his case. There was a case here in Hawaii that got thrown out like this. Someone got pulled over because the police saw she had way too many passengers in the car. Then they noticed she was drunk. Open and shut case. Well, apparently in Hawaii, there's no law defining the maximum number of passengers in a private vehicle. So the issue was that all the extra passengers weren't wearing seat belts. Well, this failed also, because the law only says that every available seatbelt needs to be in use. If you have 6 passengers and only 5 seatbelts, there's nothing at all illegal about the 6th being unrestrained. So, since there was no probable cause to pull her over in the first place, even though she was indefensibly drunk, the whole thing got thrown out. Hawaii has some very counterintuitive laws. If your truck has seats installed in the bed, your passengers must be buckled up. If not, they can just party back there, while anyone in the cab unbuckled will get you a major ticket. People regularly ride down the freeway in truck beds while sitting in lawn chairs. Not a lawyer, but I did enough law research to get myself out of a parking ticket one time. When I was in college, I was in the marching band. We had a storage room in the basement of one of the dorms. I was going to get something out of the storage room and parked in the loading dock behind the dorm. There was just enough room next to a dumpster to fit my car. I didn't want to spend $5 on a loading zone pass from parking services, because I was a broke college student, so I just parked. I was only going to be 2 minutes anyway. I finished picking up what I need to. Sure enough, I come back out to my car to a parking ticket. Except it isn't the $25 ticket for parking in a loading zone. It's a $75 ticket for parking in a fire lane. WTF. There was a single sign at the very front of the side road leading up to the loading zone, but no curb paint, no indication of where the fire lane started and where it stopped. I called parking enforcement telling them this and they wouldn't budge. Fine. I took pictures of the loading dock, and I submitted an information request to obtain the evidence pictures. I got the pictures and started researching fire lane requirements in the state. What I found clearly indicated that curb stripes were mandatory. I called parking enforcement and told them what I found and they still wouldn't budge. Frustratingly, I looked at the law again. The part they cited me for said that nothing could obstruct a fire lane at any time. I looked back at the evidence photos and saw the dumpster next to my car. If this was a fire lane, then the dumpster was blocking the fire lane too. The same state law they cited me with said that non-vehicle obstruction of a fire lane was subject to a fine of $1,500 a day. I found satellite imagery from 4 years prior showing that the dumpster had been there for at least 4 years. So I argued to university parking enforcement that if this was a fire lane, then the university had been obstructing it for at least 4 years and would owe the state $2.2 million in fines if I reported it. The parking ticket disappeared immediately when I sent the appeals committee their own evidence photos, sat imagery, and the same state law they cited me with. I drove by a week later and the dumpster was gone, the curb painted, and 2 brand new fire lane signs were up. Should have sent your evidence off anyway once the ticket was gone, lol. I have one where we won, but didn't quite go as planned. I had a client a while ago who was incarcerated at a state prison farm. Inmates had to spend 40-60 hours a week preparing slop for the hogs from expired restaurant food and cleaning the hog barns. He reeked every time I met with him, even after showering. He said it was miserable. Well, he found out that some Muslim inmates, who couldn't work with pigs, were offered to be able to work at a police horse stable instead, 5 minutes down the road. He wanted to sue, saying that stable work is much less revolting than hog work, and that this amounted to unequal punishment on the basis of religion. I thought he had a point. Well, the case didn't get thrown out and actually got some traction, but then the prison changed their policies in response. Inmates who couldn't work around pigs, or didn't want to, would instead be transported to a factory chicken barn the next county over for work each day. He asked that I drop the lawsuit, and the Muslim inmates were not happy with him. In my native country, Thailand, there used to be a punishment called kakikai for political prisoners. There was a 2-story prison. Bottom floor housed the prisoners, and the top floor was just a massive chicken cooperative. But the floor of the coop was grated, so inmates got pooped on by chickens. I had a client with a serious medical problem that cost her job, and she was preparing to file bankruptcy on the medical bills and credit card debts. Thing was, she had like $15,000 socked away and didn't tell me. It was all that was left of her life savings. Before we filed her case, she gave it to her mom for safekeeping. What she didn't know is that she could have kept the money through the bankruptcy, but giving it away beforehand is a no-no. I had to tell the court when I found out, and when this happens the court gets the right to sue the mom for the $15,000. The thing is, the mom's debt to her daughter's bankruptcy court, also dischargeable in bankruptcy, so the mom filed bankruptcy too, and they got to keep the money after all. Over 10 years ago, I had been at fault for rear-ending someone else. I had no insurance and my license had expired. I don't think I need to mention that I was in a very destitute, low place in life, struggling with almost every conceivable aspect of living. The cop was very kind as we talked, but wrote me a ticket for it all. One was kind of a fix-it ticket about my suspended license. I sorted that out in the days after and nothing came of that ticket. The cop had mentioned that he had to write the insurance ticket, but to take it into court and get it lowered. I was desperate to try and get my $800 insurance ticket lowered because I couldn't afford something like that. So I took the cop's advice. I went into traffic court weeks later, and when it was my time to chat with the judge in front of everyone there, the judge looked at the ticket, stopped me and said, "I would like to use Mr. South Seattle's case as an example to the gallery. I almost died." He went on, "This is a court of law, but it is also a court of fairness. It seems as if the officer didn't write the date of the incident in the ticket. I can't hold Mr. South Seattle accountable to this." My jaw dropped. I stood there. The judge told me I was free to go twice before it registered. I'm pretty sure that cop deliberately didn't write the date on that ticket. Thanks, officer. A guy got drunk and decided to ride his horse through town. This was a small town in North Carolina. Well, he would stop at each intersection and fire his pistol in the air like some Wild West cowboy. Anyway, the guy was charged with a DUI and discharging a firearm within city limits, which was a felony. So as one would soon find, it is not just mandatory but a law that you must fire your firearm into the air at an intersection when coming through town on your horse. An old blue law that never got erased. He still got the DUI and his horse got impounded, but the dumbfounded judge dropped the other charges. I find the mental image of the police impounding a horse quite hilarious. Had a case where my defendant opponent filed an appeal from an administrative agency to the local circuit court. The requirements for filing the appeal are very strict, and the filing must include an appeal bond, executed by the individual defendant, or a corporate officer. When my opponent's assistant electronically filed the appeal, she attached a .pdf of the bond without the corporate signature. There's no question in my mind they had the bond with the requisite signature, and simply attached the wrong version of the documents to the filing. Wish I could say there was a huge court fight over this, and I got to slam my opponent, but that's not how this works among professionals. I waited until after the time to correct this error had passed. I then politely called my opponent, told him that I was holding the I win button, and that I'd be filing a motion to that effect in a week. My opponent came to me with very favorable settlement terms within days. To this day, I don't know for sure if my opponent ever disclosed his mistake to his client, but I doubt it. Typical in-law, but the first and only time I ever used the subway station's emergency door to get to the train. The ticket gate wasn't working. It was 3 AM. I was a drunk college kid trying to catch the last train home. I got caught by 2 subway officers and given a ticket with a huge attempted fare avoidance fine. I showed up to the hearing in desperation, and they ended up having to drop the fine as they were reviewing the case with me because one cop had recorded that I entered through the right hand emergency door and the other wrote that I entered through the left hand emergency door. Never been so grateful in my life. I'm just picturing 2 angry NYPD officers yelling at each other in a comedic fashion. Damn it, Tony, my left not your left, and so on. Oh, and of course one of the cops has to throw down his hat in anger. Once won a case that forbade the possession or transport of human urine in order to adulterate a urine screen. It wasn't human urine, it was fake lab-made urine from a website. Another one, Grandpa, tell me about cornhole board guy. Happened to me when I was a teenager. My friends and I bought some beer and then went to a high school football game the first week of my senior year. We obviously got caught and all 6 of us got tickets for underage possession of alcohol. I was the DD and had been driving my dad's Suburban with our very unique last name on the license plate, so it was really easy to figure out whose car it was. Went to court a few months later. The Ada presents her case. Cops testify. They even brought the alcohol in as evidence. Right after she rested her case, my attorney steps up and asks the judge to dismiss the case. We are all very confused. The judge looks at the Ada and just kind of shakes her head and agrees. My attorney explained later that she forgot to prove that we were under 21, so there wasn't a case anymore. I've never been so glad for a technicality in my life. And that's why you hire a lawyer. Well, and to negotiate on your behalf when you're clearly guilty. My brother is a lawyer. He got a DUI charge dropped for a client. Guy gets pulled over. Cop asks him to step out to perform the sobriety test after he admits to having consumed some amount of alcohol. He complies, but after stepping out of his car asks the officer if it's okay for him to reposition his vehicle to move it further away from the road because he feels uncomfortable being that close. The cop obliges. Apparently the charge got dropped because the officer willingly let an intoxicated individual operate a motor vehicle. I once had a client who woke up in the middle of the night to the sound of someone in his home. He retrieved a Colt 1911 from a bedside drawer, walked into his living room and confronted a figure in the dark. The person didn't identify himself but moved towards my client, who fired a single shot that went through the person's shoulder. Turned out it was my client's stepson who had snuck out, been drinking underage, and stumbled home. The problem with the situation was that my client was a convicted felon several times over. That meant that while the shooting itself was legally defensible, his possession of the firearm was not. We looked into the history of the gun itself, as our client had indicated it had belonged to his grandfather, who had served in the US Army in the early 20th century. Ultimately, we were able to bring multiple experts in and establish that the gun had been among the very first batch of firearms distributed from Colt to the US Army at the Augusta Armory. Florida Statute 790.001 creates an exemption of firearm-related laws, including the prohibition for felons to possess a firearm if the firearm in question was an antique, meaning it was manufactured prior to 1918. Since we could establish the history of the firearm to have been manufactured before 1918, our client couldn't be prosecuted for the offense and got out from underneath a potential mandatory prison sentence. That's some beautiful lawyering right there, but also your client probably needed a divorce lawyer after this. Prior to becoming an attorney, I worked retail for a few months. The way my assistant manager scheduled me, I had to work 10 days straight, including a couple of 12-hour shifts, with no days off and minimal overtime. The way they got around the overtime was by scheduling me the last 5 days of one week and the first 5 days of the second week, so I only worked 40 hours in the work week plus the 4 hours of overtime for the 12-hour shift. That did not seem right to me, so I looked up the law in Virginia. While they could technically do that, there was an archaic law at the time in Virginia that stated if a non-essential or non-managerial worker wanted Sundays off, the job had to give the Sundays off without penalty. This was true even if the worker agreed in accepting the job to work on Sundays. The worker, under the law, could change his or her mind and ask for all Sundays off. As long as the worker was not essential or a manager, then the employer had to accommodate. I took the law to my manager and said that I was not going to work Sundays anymore. He said that they wouldn't schedule me that many days in a row anymore, but I still had to work Sundays. I told him that I did not and gave him the statute. It caused a big stink and I ultimately found a better job not long after, but I never worked a Sunday there again. Ironically, a few years later the Virginia General Assembly accidentally created a law that nullified the essential worker and manager bit of the Sunday law. That made the news and suddenly people were aware of this archaic law that they could ask for Sundays off. I remember the news saying that no one knew about this law, because I thought to myself, I did. The General Assembly repealed the entire law about Sundays, so now, workers do have to work Sundays. That was the only time though that I found an archaic law to help me out. Man, that pisses me off when managers give crappy schedules like that. I've known a bunch of friends who've had to work 10 days in a row or something ridiculous. Really sucks that the law got repealed. I heard that Virginia is at the bottom when it comes to workers' rights. Not a lawyer, but I got a charge drop because of the cop's bad handwriting. I got a ticket on a Monday night for speeding, and was given the court date of like 2 months from then. About a week and a half later, I get a letter in the mail that I'm being charged with a failure to appear for court. I'm in court 2 days later for that, and tell the judge not guilty on the FTA, and no contest on the speeding. After asking him to just look at the date on the ticket and my supposed original court date, he sets them down and goes, "You have a point there. Not guilty on the failure to appear. And how do you plead for the speeding charge?" I replied, "No contest. I was speeding, Your Honor." He looks at the ticket, sees that the cop had initially put 10 over and in the notes put my actual speed, like 20-30 over, and goes, "Yes, it certainly looks that way, LOL." Early in my career I had a fairly minor case in which my client's neighbor cut down a bunch of shrubs and small trees bordering their properties because they blocked his view. This really irritated my client as he wanted his privacy. Now, the monetary damages were actually not that much and this was looking like a case that really couldn't be economically litigated for what the client could afford. However, in researching the issue I found a rather obscure law that provides for attorney's fees to a winning plaintiff when a defendant has willfully damaged the border foliage of a ranch or farm. In looking up the definition of these terms, I realized that my client's property actually qualified for the statute as he used his land for growing a variety of produce for market. Once attorney's fees were on the table, the other side quickly caved and wrote a big check to cover the damages. I wasn't the lawyer, but a bailiff at the time. This wasn't strange so much as funny in a way. So an officer pulled over a man for obviously driving while intoxicated, or so it seemed, swerving a bit slower than expected for the flow of traffic, which, yes, that can get you a ticket, and blowing through a stop sign. Soon as the officer pulled the guy over, the man stepped out of the vehicle and took a big butt swig from a bottle of whiskey. Officer arrested him with DUI, and dude did blow well over the legal limit. Fast forward to the trial. The guy's lawyer argued that while his client may have been impaired driving, The fact remains that since he drank a big swig of alcohol as soon as he was stopped and stepped out of the vehicle, the officer couldn't be certain if that was what pushed him over the legal limit or not. The lawyer countered that the officer couldn't then reasonably charge him with DUI, as it was entirely possible that he was fine before that last big gulp. Long story short, the judge agreed and had to throw out the DUI charge, though he didn't want to, as he reasoned that while the defendant's reasoning was sound in the law, by the same token he feared it might encourage abuse. Whatever the case, the guy got off on the DUI charge. I later heard that this may not have been the first time the guy has tried that stunt. I've heard of this strategy many times over the years. In TX he could have been charged with an open container and public intoxication, as well as driving while intoxicated if the keys were still in the ignition. Had a client who was a truck driver. He got various penal infractions for issues with his truck. Several $1,000s in fines basically. Anyway, the evidence is pretty damning. Lots of pictures showing defects, detailed description by the traffic control officer, and so on. However, to find him guilty, the prosecutor technically has to prove that the vehicle he was driving is considered a heavy vehicle. The law says 3. Heavy vehicle means a road vehicle or combination of road vehicles, within the meaning of the Highway Safety Code, having a gross vehicle weight rating or gross combination weight rating of 4,500 kilograms or more. B. A bus, minibus or tow truck, within the meaning of that code. C. A road vehicle subject to a regulation made under section 622 of that code. The traffic control officer had not listed the weight of the vehicle in his report. There's pictures of it, clearly an 18-wheel truck, in the report but no weight written anywhere. So, I told the judge that the prosecution hadn't proven the weight of the vehicle per the definition of heavy vehicle. The pictures don't prove the numerical weight, just the shape of the vehicle. She had no choice but to acquit him because all of the infractions he had received were for a heavy vehicle operator, so he can't be guilty if they can't prove he was operating a heavy vehicle. Statute made it a crime to build structures in the park, i.e. homeless tents. My guy gets picked up. With zero prep I get up, look at the statute, and see there's an exception, if they have the governor's, mayor's, or park's debt permission. I said the ticket didn't say they checked for permission and they won't be able to prove that, so it should be dismissed for lack of probable cause. Judge, who hated the criminalization of poverty, threw it out. Obligatory ENL disclaimer. My mom was getting sued by a debt collection company that was well known for suing people as a means of threatening them. I had some time and I looked up the laws on debt collection. Where we lived at the time, you had the right to demand in writing that they provide evidence that they actually hold the debt and they had a certain amount of time to respond under the law or they forfeit any right they had to collect said debt. I sent them a certified letter. We never heard back from them. When we went to court, I submitted the receipt for the certified letter and said they had failed to provide the proof within the legal time frame and cited the law. Case dismissed, with prejudice. The lawyer for their side didn't even care. You can't lose too much sleep over your client's mistakes. Sometimes a client messes up a case or walks right into a trap. It is what it is. If I can't fix it, no sense wasting more time on it than it's worth. I've seen parties waste easily $50k in legal expenses for the chance to get $30k. It's stupid if it's coming from the client, and sleazy if it's coming from the lawyer. I had one where a client was contesting a will. Halfway through the case, the other side argued that my client was set to inherit less without the will, if we won, than she would with it, if we lost, and argued she lacked standing to attack the will. The decedent had a very old will that benefited our client's deceased mother, but that will had been revoked. We found a very old doctrine in a footnote to something else entirely and argued to the judge that the law assumes you'd rather die with an old, revoked will than with none at all. Therefore, we argued he should look back to the prior will. Since our client would inherit her mother's bequest under the prior will, he held our client had standing to bring the will contest. We ended up settling the case shortly thereafter. I never got why people contest wills so fiercely. It's like even in times of grief, money still makes people into terrible persons and can tear families apart over it. In my family, an old uncle died and one cousin was named in the will but wanted her mom to be named too. They fought so long over it that the mom died and the money ended up going to paying lawyers' court costs. Not me personally, but this was a case we covered in my first year of law school. Essentially, in 1912 the Appellate Division held that women could not be lawyers in South Africa as the relevant statute referred to person, and women were less than a person. Incorporated Law Society v. Wookie. 14 years later, activist-minded judges applied this finding to a past law case during apartheid. To sum it up, they reasoned that because women were not people, and only black people were required to carry a pass, black women were not required to and could not be arrested or penalized for not having a pass. Rex v. Letterdy. Had a guy in USAF basic training that should have been a lawyer. When pulling dorm guard duty we were supposed to ask anyone requesting entry to show their military ID through the window at the door, and compare the name shown to an approved entry list. Failure to confirm it before allowing entry was a security infraction. So this one dude is dorm guard when a TI, training instructor, is going around from dorm to dorm to make sure the airmen on duty are following procedures. The TI knocks on the door and demands entry. For whatever reason, the airman lets the TI in without asking to see it. The TI blows a gasket and starts screaming at the airman how much trouble he's going to be in when the TI reports what happened. He demands the airman hand over a Form 341, which is used to document rules infractions. Airman: sir, I'll give you a 341, but I think you should know this door is broken. TI: WFT are you talking about, airman? Airman: sir, we found out if you kick the door on the bottom left corner it opens whether it's locked or not. TI: show me what you're talking about. The two step out into the hallway and the airman shows the TI where to kick the door. Airman: sir, let me step back inside and lock the door so you can try it yourself. The airman steps back inside the door, then locks it. The TI tries kicking the door, but it remains locked. TI: airman: I thought you said this door is broken. Airman: huh, it worked the last time I tried it. TI: well, it looks like it's working fine now. Open up and give me a 341. Airman: sir, if you are requesting entry to the dorm I'll have to see your ID first. I once got out of a parking ticket by refusing to admit I was the driver. In the UK, parking companies that use automatic number plate recognition can get the contact details of the registered keeper of a car from the DVLA, our DMV, and send them the fine in the post. But I did some googling and found out that legally it's not the registered keeper who is liable for the fine. It's whoever was driving at the time. This isn't always the case. There are situations where they can hold the keeper liable, but in my specific case this didn't apply. They really don't like you knowing this. Their letters are worded very carefully to give you the impression that you are liable for the fine as keeper of the vehicle without ever actually outright saying that. And they do the crap where you can either pay a reduced fine now, or appeal and pay a bigger fine later. I appealed. I didn't lie and claim I wasn't the driver. Instead I just pointed out that they are contacting me as the registered keeper, that the registered keeper isn't legally liable to pay the fine, and that I am under no obligation to give them any details of who was driving at the time. It took months and 2 appeals, but eventually I won and didn't have to pay the £20 fine. I would have paid, but I felt like I hadn't done anything wrong. I'd not parked illegally or overtime or not paid or anything. I'd just forgotten to validate my parking after shopping at Tesco. If you are new to the channel, you can subscribe. I publish new videos every day. Until then, check another video. Bye for now.